Good afternoon, everyone. Thank you for joining us. My name is Daniel O'Neill. I'm one of the co-chairs of the HYLA CLE committee. We have an amazing presentation coming up today, so we really appreciate you all joining us. For those of you who have been a part of our CLE committee offerings for a while, you may recognize who is here today. Angela Oakes practices with the Oakes Law Firm. I've known her for 6 years. We used to practice together. She's one of the finest lawyers I've ever worked with. Even though we no longer practice together, she is still my moral compass and somebody I frequently go to for advice, and I consider a mentor. So I'm really grateful that she agreed to come back to the CLE committee and make another presentation. This is going to be a mostly kind of practical experience presentation, so y'all should be able to walk away with some really good knowledge and practical experience. Modifications are a huge deal in the family law community, whether you have pro bono clients or paying clients. If you log on to the HBL portal, use Multi Lawyers, there's a huge number of modification cases that need assignments. So potentially some of you are here because you're interested in taking on one of those cases, or I don't recognize all the names if you all happen to practice family law. Since this is set up in webinar mode, I don't think you all can camera in, but if you have any questions for Angela or for me, just type them in the chat box and we'll make sure that they get answered. I have the MCLE number I'll give you at the end of the presentation, so hold on for that. You can either self-report, or if you want Lucy to do it for you, you're going to have to email her directly. So make sure you get her email address as well. So at this point, I'm going to introduce Angela, and take it away, please.
Hello, everyone. And Daniel, thank you so much for having me again. It's such an honor to come and speak to you all today. And I'm so honored to know Daniel and be considered his mentor. That means a lot to me. So I was on a Zoom call last week. It was a CLE regarding the changes to our disciplinary rules. And my understanding was that there were over 1,700 other attorneys on that Zoom call. I'm sure some of you were on that Zoom call. And it struck me how proud I am to be a part of this profession, and just how fortunate I am to be able to do what I do. So I'm really delighted I can come and talk to everybody today. Thank you, Daniel. So one of the presenters on that CLE said something, and the moment I heard it, I thought, I am taking that, I'm using it for my CLE next week. And it was, what is your favorite aspect of being a lawyer? And for me, it's the ability to help people. I get to use my knowledge to help others during one of the most difficult periods of their life, whether it is a divorce or custody suit. These areas that occur are hugely impactful on people's lives, and I get to help them through that. And I love that. And that makes me the most proud of my law degree and what I'm doing with it. And that's the focus of my presentation: how to help your family law clients through the use of temporary orders specifically, and more to the point, to avoid a future modification in the future. If you use your temporary orders correctly, you can avoid that modification in the future, which is hugely complicated and expensive, and we're going to get to that in just a minute. All right, bear with me, folks. I'm going to share screen and open up a quick PowerPoint, which is very short. I promise I didn't do anything crazy. Believe it or not, I'm in court almost every day on Zoom, and I have to share screens and actually do stuff like this. And it normally works, so bear with me for half a second here. All right, so the first thing I wanted to do was just put up my contact information, and I want you to be able to contact me at any time. If you reach out to me with an email or a phone call, I'm happy to. Wow. I just said I do this all the time, didn't I? That is pretty much why this isn't going to work today, isn't it? Well, tell you what, gonna go back to the Zoom, gonna hit stop share, And this is what we do in court too. When things don't work like you're supposed to, you move on, you recenter, you move on, it all works out. All right, so let's start with what are temporary orders? Well, temporary orders are an opportunity to set into place a court order during the pendency of your case. It can regard property, payment of normal and ongoing debts, payment of attorney's fees, possession of the children, payment of the healthcare insurance, rights and duties regarding the children, and of course, possession and access. I know that each of you has been asked somewhere in your legal career, and maybe probably, in fact, it was in law school, how quickly can I get divorced in Texas? And the answer, which most of you know, is 61 days. 61 days from the date of filing, you can finalize a divorce in Texas. I think the question that we always have to ask ourselves is, should you finalize within 61 days? Because fast is not always the best way to go. Sometimes it's better to take it slow, live under the temporary orders for a while, see how this new living situation is working for your client. You know, they don't always have the same knowledge that you do about the process and the intricate details that go into a temporary order, or go into a final for that matter, that are going to impact their lives going forward. I think there is a learning curve when a client files for divorce, separates their lives physically and emotionally, and it just takes some time for clients to figure out how life is going to look going forward. So by putting a temporary order in place, you can help them understand what life's going to look like and what's going to work for their family. So the Texas Family Code allows for temp orders in most all family cases. If you are filing for a divorce without children, your temporary orders fall under section 6.502. If you are filing a suit affecting parent-child relationship only, maybe the parties were never married, but there is a child, temporary orders are governed under section 105.001. And if you are filing a modification, and we'll talk about modifications here in a second, but maybe you weren't the attorney on the first case or the divorce or the initial SAPSR. If you are filing a modification, you can still get a temp orders hearing under 106.006, 156.006. That's the modification statute. When I meet with a client, and so many of our clients, the first thing they say is, I want to be divorced yesterday. I never want to talk to this person again. I start by asking, is there a reason? Other than you never want to see their face, is there a reason to get you divorced quickly? For example, maybe the affair is pregnant and they want to get married before that child is born, so that child is not born out of wedlock. Of course, that only works if there is a male in the spousal unit, because if a female is pregnant during the pendency of a divorce, you cannot divorce until the baby's born. So, but let's say that there is a girlfriend and she's pregnant and husband needs to marry prior to when the baby is born. Well, then I can see how it makes sense to push forward with a quick divorce and, utilize that 61-day rule and get the divorce. And, as I was preparing this, I thought about what would happen if both the parties were female in the divorce. Would the court still put the case on hold, waiting for the baby to be born? Because you're not actually creating a child without a father at that point. It's a same-sex marriage, and I find that interesting. My guess is that the court would put it on hold, but I don't know. Another scenario why it might make sense to move forward quickly with that quick divorce is if there is a bankruptcy that has not been filed, right? Filing a bankruptcy will put a divorce on stay just like that. But let's say that the bankruptcy has not been filed, but it's looming and you can see that it's coming and the parties really just want to be divorced first. Maybe one of the parties has the bulk of the debt in their own name, and therefore, or it's business debt, and therefore it makes sense to divide the community estate and get the parties divorced so that the other spouse is not affected by the bankruptcy. Then to me, it makes complete sense to go ahead and get that divorce done quickly. But I will say, I'll be practicing 13 years in May. And in 13 years, I have seen 4 divorces happen in that 60 to 65 day period, 4 of them. And one of them was my own. It was my second marriage, second divorce. I had a prenup. We had no children, and it just made sense to get it done quickly. But that's not many. That is not many. I have done hundreds and hundreds. I'm probably getting close to the 10,000 divorce and SAPSR cases at this point, and only 4 of them in 13 years. So just remember, it's not always wise or possible to get it done that quickly. Let's see. Some of the things that will indicate to me that a client needs to take their time in the divorce. Do they have children that they are going to have to start figuring out where the children are going to be, what the rights and duties look like, how are the children going to react to living in 2 different households? Do they have pets that they expect to share? Because if you think doing a property division with children is difficult, wait till you add in a pet that is going to be shared between the 2 parties post-divorce. Or if they have property that is complex. For example, maybe one party doesn't know the bulk of the community estate, doesn't know where the assets are or what they are or what the value is. You simply can't get into a quick divorce in that scenario because you've got to figure out where the pieces are at. So one of the things that you can do in a temporary order, let me back up. We talked earlier about the statutes in the family code that allow for temporary orders. When you request temporary orders in a brand new divorce, they are always granted by the court. The court has to give you a court date to approach the court on a temporary orders scenario, because in just a straight divorce, no children, you've got to establish who's going to pay for what. Right? There is no scenario in which the court's going to let everybody just flounder during the pendency of a divorce. You've got to establish who's going to live where, who's going to pay for what during the pendency of the divorce. When you are filing suit on a SAPSR, same issues. The court is always going to give you a temporary orders hearing date so that there are orders regarding the children. And the court's going to make you mediate, and the court's going to hope that you reach agreement, but you are always going to have a hearing date. So you can figure out what do the temp orders look like for these kids. It's different on a modification. On a modification, you've got to convince the court to give you a temporary orders hearing date. And that's not always possible. For example, some of the courts that I practice primarily in Harris County and Fort Bend and Montgomery. Some of the courts that I practice in, they don't want to see me on temporary orders for a modification. I've got to show that there is a significant impairment to the child or a danger to the child, or something is happening that would indicate to the court that I've got to get in the courtroom. I've got to get in quick. We've got to do something for this child. And if my modification case doesn't rise to that level, I don't get a temporary orders hearing. So that's just something to think about when you are planning for how to proceed with your case and what's going to work best for your client. So talking just about the money issues that you can address in a temporary orders hearing. And you think of it as, how do I maintain the status quo for my client? Now that divorce has been filed, divorce will be finalized eventually, but we've got to put all the pieces together. How do I maintain status quo? I'm talking, how do I keep the cell phone on? How do I keep the mortgage paid? How do I keep attorney's fees paid? How do I keep health insurance intact? And I see we have a question. I'm going to get right back to that. Hang on, okay? When I go in front of a court on temporary orders, you always want to have pulled together a financial information statement that details what the expenses are going to be, and also come into court with a plan for, all right, if my client pays 25% of the cell phone bill, this is what we need from the other side to keep that cell phone on. And most of the courts do require mediation prior. Most cases do settle at mediation, at least under temporary. I would say less than 15% of the time do you end up going to a full hearing on a temporary hearing, because it is temporary. It provides both parties with an opportunity to see how life is going to work as they progress towards that final divorce. And I think it provides a sense of comfort. I know it does for me, but I think it provides a sense of comfort for the clients as well, knowing that, okay, my rent is going to be paid by, in this way for this many months under temporary orders. Hey, Daniel, I'm going to go to that question real quick. What situations rise to the level of a temporary orders hearing and modification? Okay, that is a really good question. When I'm bringing a modification, I'm getting a little off track. See, look at me, my head's spinning. Okay. When I bring a modification, I have to establish that there has been a material and substantial change of circumstances. Keep that in your mind. We're going to come back to that. That's kind of how do I kick open the door of the courthouse? I get a material and substantial change of circumstances, and I have to put that in my pleading and my affidavit, and we have to attest that that is actually going on, right? But what are some of the circumstances that can get me a temp orders hearing? The child is experiencing trauma. I'm seeing a lot of suicidal ideation, suicidal threats, self-harm issues right now are opening that door to the courtroom on a modification. If I've got a child who was doing well in school and is now not, of course, any indication of abuse by, hopefully not my client, hopefully the other side, but sometimes any indication of abuse, that would be a material and substantial change of circumstances affecting the child, which is going to allow me back into the courtroom. Does that help? Okay, let me get back to my bullet points here. The other thing that I like to do in temporary orders is do not a full split of the personal property, not, a full split of who takes the couch and who gets the TV in the spare bedroom and who gets the silverware that Aunt Ida gave us for our wedding, but some sort of a split, some sort of a, go in and get a box of kitchen things, because I wasn't part of it. I've heard the story about the divorcee who said, I don't want anything, give her everything. I'm walking away with nothing. And 2 months later finds himself sitting on the floor of his apartment with no furniture, no television, eating with, throwaway utensils because he didn't get anything. And that story is always in the back of my mind when I'm setting forward temporary orders, because I want to make sure my client has at least the creature comforts, right? You want your favorite blanket, you want your favorite towel, you want that favorite plate or cereal bowl that you use every Saturday morning, and you want to get those things as you start to rebuild your life. So even if I'm talking to a client that says to me, I don't want anything, I don't want anything. Okay, how are you going to eat your cereal on Saturday morning? And then I start them thinking about, oh, you're right. Well, I'll just go buy new. Okay, do you know what that's going to cost you to buy new? Do you want to spend that kind of money to buy new? And some clients do. Some clients really do want a complete break to just, wash their hands of it. But I like to get them thinking about, okay, what's your favorite chair? You going to miss it? How about the tools in the garage? Are there tools in the garage that you're going to need to start over? Do you know the cost of the replacement? Just get your client thinking about what makes sense. Okay, we've got another question here. Have there been a lot of situations where one parent is being reckless with COVID and the other is not? Ooh, this is good. Arguing hard on the child, yada, yada. Are the courts receptive? Does it make a difference? Okay. This question actually comes up probably about the right amount of time you think it comes up. All of my clients are contacting me about this right now because there are very few of my clients And you know, here they got divorced for a reason, right? They're not together because they're not approaching the parenting probably in the same way. So many of my clients are asking me this question. So let me tell you what I tell them. The Supreme Court of Texas, very early on the COVID situation, came out with a guideline that parents should continue to follow their parenting orders, and regardless of COVID going on, they still have to exchange the children. I have seen no other guide come out since, and that was, I want to say, last April or March. No, I'm sorry, April or May. I do not know, because we have been so poor with our tracing. Could we assign a child's contraction of COVID to one parent or the other? Let's say they're working on an expanded standard possession order. Kids have been going back and forth, you know, every Thursday at a minimum, and probably first, third, and fifth weekends. And given how COVID transfers, the incubation period, could we assign the fault of that child then getting COVID to one parent or the other? I don't think that we could. I don't think, with the technology that we've got right now and the medical tracing that is available right now, I don't think that we could. If that changes, I think we're going to see 100 of these cases filed the next day. I think there are so many parents right now who are just beside themselves because they have been masking, they have been careful, they aren't ordering food from restaurants that aren't forcing people to mask. And the other parent is not. In fact, the other parent might be taking the child out to a rally where no one's wearing a mask, and they are so frustrated, but we can't trace it right now. So how do I hold the other parent responsible? So, to a very long answer to a very brief question, I don't know right now. I haven't brought any of those cases myself. I haven't had one of those cases brought against one of my clients. I haven't seen a ruling come out of an appellate court about COVID specifically. But I expect to see them. I do. They're coming, especially if we have a child who dies. We're definitely going to see a lawsuit then, or complications from COVID, 10 years from now, but we've got better tracing. They're coming next year. We'll do a CLE on that one next year. I want to talk very quickly about getting a temp order in place in order to get something for the non-moneyed spouse that maybe you can't even begin to get at trial. And for me, what comes to mind instantly is spousal support. So spousal support in Texas is very hard to get. I know that we have guidelines about, if you were married X number of years, you get 20% of gross income for X number of years, and it sounds very cut and dried. But the criteria for establishing spousal support in Texas is, one, the non-moneyed spouse is unable to meet their own minimum reasonable needs, which is a pretty low bar. And two, that spouse is looking for work and unable to find it. So what I encourage my clients to do, one, we put together a financial information statement to show minimum reasonable needs, right? But two, they're applying for jobs every day. They're working with the Texas Workforce Commission, because I know I have to prove to a judge that my client is making every possible opportunity to become employed. And that's what usually trips you up, because if you've got a client who can string words together, they're probably going to be employed if they are applying for 3 to 5 jobs every day and working with the Texas Workforce Commission. But none of those, and you may not have a client who has been married long enough to get spousal support in Texas. They might have a 3 or 4 year marriage, and you need a 10-year marriage minimum to start looking at spousal support long term. But what you can do in temporary orders is ask the court to maintain status quo. So it's not actually a spousal support award. It is a a support award. And I know that seems crazy, but we're lawyers, so we deal with crazy all the time, right? It's not spousal support, it is support. And what that means is money coming in for rent, money coming in for cell phone, maintaining the health insurance, all of these things that I've talked about already. You can get that for a client that may not be eligible for spousal support. You can get that under temporary. And any of you who have applied for temporary orders and gotten temporary orders know that temporary orders last until final orders go into effect. And depending on what court you're in front of, that can last a long time. So if you can get a temporary support award for the non-moneyed spouse under temporary orders, you can use that to help them get on their feet, because they're probably going to have a job by the time you get to final trial. And if they don't, you are not going to get the amount of spousal support that you are wanting for them. You are going to get less. So getting them something under temporary helps them at least get their feet under them. Kids. Let's talk about kids real quick. So adding children to an already fraught situation of divorce just adds that much more complication. I frankly would never recommend going straight to final on a divorce if you've got children involved. You've got to give yourself a moment to work under temporary orders and see how it's going to work for your child, because the Texas legislature has created this great system that we all use, we all quote. It is the standard possession order, first, third, and fifth weekend, and Thursdays for 2 hours, or an expanded standard possession order, which is first, third, and fifth weekend plus Thursday overnights. And most of my clients figure out how to make that work. But every once in a while, you get a client whose child simply does not adjust well to that scenario. And I also think that parents have to learn to adjust to that scenario. If you've got, let's say dad is an engineer and dad's been helping with the homework for the last 10 years, and suddenly dad is the weekend parent, and that child's not getting help during the week like they used to on their science homework, that child's grades are going to decline. And if you ride under temporary orders for 6 months or more, you're going to see a full semester's worth of grades and witness that decline. And when you get to a final orders mediation or you get to final trial, well, now you can bring that up and discuss how to make that better for this child. Because this child should not be suffering because his parents couldn't stay together. The child should be supported. So how do we do that? We can get really creative. We can come up with, dad comes over for an hour and a half every evening. They get on Zoom and do homework every evening. Or maybe the child lives with dad during the week and sees mom on the weekends. All kinds of things you can do, but you wouldn't know to even start looking for them if you didn't let yourself kind of simmer under temporary orders. Another thing to consider under temp orders is phone access. Many of my clients think, well, I can't go 24 hours without talking to my kid. I want phone access every day. And while that sounds lovely, and I'm a parent, I get that, it's not actually as helpful as you might think. So imagine you are with your kid. You're doing a project, you're making dinner, you're watching a movie, and oh, it's 8 o'clock, you have to take 15 minutes to go talk to your dad. Well, now you've taken your special time with your child and you are chopping it up, okay? And let's say while the kid is talking to dad, dad says something, maybe just offhand, hey, I can't wait to see you this weekend. I miss you so much. This divorce just sucks, doesn't it? And now child comes back after the phone call and they're upset and your whole night is thrown off, right? And I'm not saying this happens with all clients, but there are a significant number of clients that experience this with that phone call every day. You wouldn't know that unless you had lived under temporary orders for a little while. You wouldn't know that by the time you get to final, you can come up with some telephone language that is going to be more beneficial, not put your child into a state of mind that, oh, this divorce is still happening. I can't believe my parents are going through this every single night. And you can work with that. And then you could also find out the opposite, that in temp orders, you've got one phone call a week. It's not nearly enough, and you need more. My point is, while it takes a little bit of time to get your client through temporary orders and put temp orders in place, I think the benefits are just exponential, whether you are dealing with a divorce with children or just property, to live under those temp orders for a minute. I told you we would circle back to modifications. Through the questions, we've had some really good questions about modification. I want to come back to, so often in mediation especially, the mediator will say, and I work with great mediators, don't think I don't, but they'll say, we can agree to that, you can agree to that, you can always change it later in modification. And that is just not accurate. If you agree today to phone calls every night at 8 o'clock for the parent not in possession, and you decide in 6 months that you want to change that because it's just not working, you can't actually modify that case at 6 months. In order to modify at all, you have to establish a material and substantial change of circumstances. And that is a very, it is a set of guidelines that is very dependent on how your judge views whether or not there has been a material and substantial change of circumstances. And if you try to bring a modification suit within a year, within 12 months of the original case being signed, the original order being signed by the court, you have to establish that there is a health, safety, health, safety, welfare, and it can be emotional health, safety, and welfare issue with the child, in addition to your material and substantial change of circumstances. So you have an extra burden if you try and modify your order within 12 months. And I understand why the courts did this. You know, we take up a lot of court time in establishing the underlying orders. And if everyone were coming back to court within 12 months trying to change their orders because it didn't work for them, it would inundate the system. It would inundate a system that's already inundated. So I understand why the courts require that extra burden to get into the courtroom within 12 months. But let's just say that you want to bring a modification 3 years in. You want to change the way that pickup and drop off is occurring, which sounds like a very simple thing, right? You still have to establish that there has been a material and substantial change of circumstances in order to open the door to the courthouse, unless you have agreement from the other party. Let's assume no agreement in this hypothetical. So what is a material and substantial change of circumstances? Well, if you look at the case law, material and substantial change of circumstances can be birth, death, marriage, divorce, sometimes a new child, especially if you're modifying child support. A new child would change that child support calculation. But I'll tell you right now, not all judges agree that marriage, divorce, and new child are enough to change, to qualify as a material and substantial change of circumstances to get back into the courtroom. And that is very frustrating, especially when you know you are looking at the factors for material and substantial change, and you know, oh, my client got remarried, boom, I'm in. But your court doesn't agree with that. And I can hear all of you saying, well, just appeal, just appeal. That's a lovely thought. And yes, I wish that all of my clients could appeal when something like that happens. But if you think the underlying suit is expensive, appeal is crazy expensive. And I've only had a handful of clients in 13 years who could afford to push forward on an appeal. Most people have one shot. They have one shot. All of their money went into it. There's no money for an appeal. And even if they find money for an appeal, there's no guarantee it's going to be successful or timely. Appeals take forever. I know we're in COVID. I know that the rules are all changed, but I've got an appeal that has been with the 13th since November 2019, and I'm still waiting on an answer. And when you've got a child, you can't wait that long, right? So if we get temporary orders in place, see what works for our clients, then move into a final, I would like to think we can avoid modifications down the road more consistently avoid modifications. Now, you're always going to have modifications, and that's a good thing, right? Keeps us all employed. But if we can reduce those by working with temporary orders, I think that is a better use of our knowledge and our clients' money as well. I just want to point out that material and substantial changes, a child getting older is not a material and substantial change. A child even wanting to live with the other parent might not be considered a material and substantial change unless that other parent has allowed your client to have more time with the child. They're very fact-specific cases, and your judge has a lot of power in determining whether or not you get to stay in the courtroom on a modification. Now, there is kind of a double-edged sword with temp orders, and that double-edged sword is that it's the underlying principle, best interest of the child. Courts do not like to muck around with kids' lives if they don't have to. And what that means in going from a temporary to a final situation is that the court is likely to follow what happened in temporary orders, likely to do exactly what the possession and access schedule is, the rights and duties, the child support. In temp, they're going to extend that to final. So as you are thinking about your case and preparing your case, keep in mind that if you didn't get what you wanted in temporary orders, you better come up with something really good to convince the judge at final that things should change. And you better tie that back into best interest of the children, because it is not convenience of the parents. It is not wishes of the parents. It is, how is this decision going to affect these children? That's what the judges are looking for. And that's a tough one, especially when we, as the lawyers who are representing the parents, don't get to talk to the kids. We can't talk to the kids. Even if we could talk to the kids, we can't bring that information into the courtroom. That's a tough one, to tie it all back into best interest of the child, something that might look like convenience for a parent. And switching schools for when you are going from a temp order situation to a final situation and you're in front of a judge, asking the judge to force a child to switch schools is the kiss of death. I would not recommend that. I'm actually going to share with you a story here in a second where that worked, but it was the only time I've ever seen that work. Do not ask a court to switch schools. In fact, it is usually a better idea to get your client to move into that school district than to expect a judge to force children to move schools. They're not going to do it. Okay, so just in closing, it's not always possible to get this right the first time. Under temp orders, things can go south. But what following temp orders allows you to do is find out what is not working and come up with a better solution in mediation for final, or prepare your case for final trial to get to that solution that you want, because you now have some data that this isn't working under temporary orders, and here's why. And this is affecting the children negatively, and here's why. I think your clients also come into final with a better idea of how life looks after divorce, once they've lived under the temporary order for a while. I think a lot of people who've never been through a divorce don't understand there's a lot of detail regarding your children in a divorce. There's a lot of detail about your rights and your duties, who has the kids when, giving notice for holidays, passports. I mean, you name it. We try and put it all into an order to help our clients. And I don't think a lot of people realize that, nor should they. Why should they? But once they live under temporary orders and start understanding, oh, I really do have to give notice by April 1st if I want a 30-day period in the summer that's not July, then they can start to adjust their lives accordingly. And I think that makes their lives a little bit easier post-divorce. I like to think that that's the way that I'm helping. I just want to share, and then we're almost done. I do often approach temporary orders as getting 2 bites at the apple. Let me explain that a little bit. If you can't reach agreement on a temporary order at mediation, which happens sometimes, then you have an opportunity to present evidence to a judge. Might be a judge you know, might be a judge you don't know, might be a novel issue that you haven't presented to the judge before. So you get to present your case once under temporary, and then live under temporary orders for 6, 7, 8 months, a year, year and a half sometimes, and then present that case again. And I know that seems like a lot of extra work to get to the same result, which is a divorce. But sometimes having that second bite at the apple can make all the difference. And I just want to share with you, I had a temporary orders hearing last November 2019, before COVID. Isn't that funny? Everything is either before COVID or after COVID now. I had a temporary orders hearing November of 2019. We lived under temporary orders until July of 2020. Hugely contentious case. Nobody could get along with anybody. Nobody could even agree the sky was blue. It was awful. But what I learned under temp orders was that my judge really wanted to give my client the children. He said as much in when he gave his rendition. But our judge couldn't get his head around the concept that my client spent an hour and a half each way. I'm sorry, not each way. Yeah, each way, an hour and a half each way on his commute. And my client was a teacher, which meant he had to be at school very early in the morning. And then he was also a coach, which meant he was coming home late at night. And the judge could not get his head around how much time my client was going to be away from his own children. And he said as much, and he awarded in temporary the children to mom. So I spent the entire case, which I knew was going to end up in trial because of the contentiousness of the parties. I spent the entire case figuring out, how do I reduce that goddamn commute, and how do I get the kids into dad's home? And it did not hurt that mom violated that temporary order 6 ways to Sunday. We had 2 enforcements. She continuously interfered with dad's relationship with the children. But by the time we got to court, my client was in a new school district that reduced his commute to about 10 minutes. And having that information, being able to present that to the judge, I got my second bite at the apple. At the end of that trial, all 3 of his kids are in his home. They switched schools, which never happens. Don't try that. And now mom pays the child support, sees the kids on a schedule, and the kids are doing better with their dad, which is what we needed in the first place. So that's my get your temporary orders in place. There is value in getting temporary orders in place, and hopefully we can avoid some modifications down the road if we get temp orders in place and allow our clients to live and work under them for a period of time before that final order goes into effect. Any other questions? Thank you all so much for attending. I can't see any of your faces. I'm on Zoom court almost every day, which actually is easier than going down to the courthouse. But I miss everybody. I miss seeing everybody's faces. So thank you all for listening to me go on and on. All right, here's a question. If there's a death due to COVID, how do you work this into modification? It really wouldn't be a modification suit, would it? Because if there's a dead parent, then the rights and duties and possession access would all automatically drop to the parent who's still living. And if it is a dead child, then there's no modification necessary. But so I'm actually thinking it would probably be more of a probate matter. Possibly, Daniel, would there be any sort of a personal injury? Actually, it might even be more criminal. We're probably going to see those cases come out of the probate court and the criminal courts as they come, and they will. They're coming. We just got to watch for them. Dead grandparent, parent didn't make changes to protect children. Oh, interesting, interesting. So the question came across, what if there's a dead grandparent that I'm assuming in this hypothetical the children had been exposed to? Grandparent dies from COVID. The other parent saying you really should have kept the children from grandparents during, while they were infected. I'll be the first to tell you, I will bring a crazy case. I will bring a crazy case with a crazy fact pattern just to see how it plays out, making very much sure that my client understands, I've never seen this before. I'm doing something I've never done before. This is probably crazy, but let's go see. I don't know that I would be willing to take that case. I might let somebody crazier than me take that first COVID case and get a decision and then have some ideas about how to proceed. Definitely, I think that is neglectful, possibly endangering a child. I wonder if there are some CPS actions that are happening right now around that concept. I just haven't seen them yet. They take time to get from our district courts to appellate court and then decision that we finally see. Oh, thank you for saying it was okay without the slides. I'll put that into a PDF and Lucy will send that out to everybody. I'm so sorry if there's only 6 slides, but still I put them together. I just couldn't make them go. Did everyone get the MCLE number so you can self-report? Well, thank you, everyone. I appreciate it. Everybody stay safe out there. Keep masking. We're getting to the end of COVID, I'm sure, but we gotta keep doing what we're doing right now to keep our numbers down to something manageable. And yes, you can get my email. It's angela@theoakslawfirm.com. And that will come out with the PDF that will be sent out. That's on the first and last slides, but angela@theoakslawfirm.com. And I think my website is theoakslawfirm.com.
Yeah. That was a fantastic presentation. Thank you so much for presenting today. We look forward to the one next year on all the COVID, the crazy type stuff that's going to come out over the next couple of months.
It's going to be interesting.
That's right.
And will parents take kids for vaccinations, and will they have to? And what about anti-vaxxers? Yeah, all this stuff is coming. It's coming down the road.
What a time to be alive. And for everybody that joined us, thank you again for joining us. Next month's presentation coming from the CLE committee is going to be on adoptions, and there's going to be a kind of specific emphasis on what's been happening with same-sex adoptions. So that is going to be really interesting to see kind of how that has developed over the past couple of years since the burger fell. And that's being presented by Ashley Scott. So this was the first HYLA event of the new year since we came back. So if you all, I think you all are members, but if you're not, dues are prorated for the rest of the bar year. There's a number of great events coming up. Check the email that just came out. I think that came from Christina. There's a book club I'm really looking forward to being a part of. And there's tons of other great events through the rest of the bar year. Any last minute questions before Angela signs off?
I just want to plug Ashley Scott real quick. She and I gave a presentation together at Shell on National Coming Out Day, I want to say 2 years ago. I met Ashley through a same-sex case. We both represented one of the spouses, and she's just fantastic. So I'm really tickled she's going to be presenting to you all. Please tune in and listen to her. She's great.
Oh yeah, and when you enter the MCLE number, it's a different title. Don't worry about it. It's the correct course number. But yeah, just as Christina just said, yeah, don't worry about it. And we apologize.
Yeah, Lucy, our executive director, is working on that. Apologies, everyone, but it's the correct course number, and you'll get the credit.
All right. Well, thanks everyone for joining us. Hope you had a good time. And Angela, thank you again for being so generous with your time, and this is interesting stuff to hear about. So thank you again.
Thanks for having me.